Hello, everybody. Today we will be discussing privacy related to student education records. We'll be discussing two particular laws regarding privacy, the first being the Family Educational Rights and Privacy Act, or better known as FERPA, and second being the Higher Education Act. Both laws involve privacy, and we will first start out with FERPA. The Family Educational Rights and Privacy Act is a law that's administered by the Family Policy Compliance Office with the Department of Education. FERPA applies to all educational agencies and institutions that receive federal funding that is administered by the Department of Education. And of course, our institutions receive federal funding. That is our Pell Grants, our direct loans. So we do have to comply with FERPA. Who is protected under FERPA? Once a student reaches 18 years of age or attends a post-secondary institution, he or she becomes an eligible student, and all rights formerly given to a parent transfer to that student. A parent does not have a right to a student's education records just because he is a parent. There is an exception to that, and we will discuss that later. Generally, FERPA prohibits the improper disclosure of personal identifiable information from a student's education record to a third party unless the student has provided written consent. So what exactly is considered an education record? An education record is defined as those records that contain information directly related to a student and are maintained by the educational institution or by a party acting for the institution. Information that an official obtained through personal knowledge or observation or heard orally is not necessarily considered FERPA or protected under FERPA. For example, if two colleagues are having a conversation about a student and maybe the information being discussed is relevant or related to an educational record, if that conversation is overheard, that conversation is not protected under FERPA. Also, schools are not required to maintain particular education records. So there's nothing that dictates exactly what we have to maintain in an education record, but whatever we choose to maintain is protected under FERPA. So what is considered PII? Personally identifiable information, or PII, is defined to include not only direct identifiers like student's name, social security number, but also indirect identifiers such as date of birth, mother's maiden name. It also includes other information that alone or in combination is linked or is linkable to a specific student, that it would allow a reasonable person to understand the identity of the student. Also, some cases of record may not contain direct or even indirect identifiers, but would still contain PII under FERPA. So what's considered an education record at our institution? Here are some examples. It's not just limited to these. Obviously, your file-bound files. These are files that include your academic and your financial aid information. Any placement files, whether they are stored on FileBound or whether they are stored in your desk in paper files. Diamond D records contain PII regarding individuals. This would be most of the modules within Diamond D. Loan assistance records. Certainly what loan assistance contains in their files at their site is part of a student's education record. Canvas contains grades. If you're using other outside attendance products, these are things that are part of a student's education record. There are other third parties that act on the institution's behalf, such as FAS. This is the company that is our collection agency. We send them information that is part of a student's education record. So FAS now is bound to FERPA in regards to protecting that student's information. Students have certain rights under FERPA. There are 4 basic rights that they have. The first one is they have a right to inspect and review their education record within 45 days of the request of access. Number 2, they have the right to request the amendment of the student's education record if they believe that record to be inaccurate, misleading, or otherwise in violation of the student's privacy under FERPA. We are not required to automatically amend a record if it's requested, but we are required to consider the request. Also, it does afford an eligible student the right to amend their records, but it doesn't give them the right to challenge a grade, an individual's opinion, or a decision that was made by the school. Number 3, they have the right to provide written consent before the school discloses PII from a student's education record, except to the extent that FERPA authorizes disclosure without their consent. And there are a number of exceptions where we are allowed to release information without consent, and we will discuss that here in a little bit. But if one of those exceptions do not apply, then they have the right to provide written consent before we release any information out of their education record. And finally, number 4, they have a right to file a complaint with the U.S. Department of Education concerning any alleged failures by us to comply with FERPA. So how do they receive notification of these rights? We notify our students annually. We also notify them up front when they first enroll. We give them a document that's entitled, "We want you to be a well-informed consumer," that is handed out by the financial aid office. And on that form, we tell them all the different things that we are required to disclose. And also, every year before July 1, we send them a notice. And in that notice, we tell them where they can find their notification of rights. That notice is placed on our institution's website, and it's under the consumer information link. This example I'm showing you on the slide is West Virginia Junior College. Obviously, if you are an employee of PIHT or OVCT or UCI, then your students will be given the URL for your institution's homepage. So if one of the reasons that we can release without consent does not apply, we must obtain written consent in writing from the student. We have a form called the Release of Information Disclosure. This form is completed by all students prior to release of information. This form is maintained in the student's education record. This form is housed in Adobe Sign. It can be sent to the student electronically via Adobe Sign, or we can print a PDF version if the student fills it out manually. So we're going to briefly go through some of the reasons why we may be allowed to release students' information without consent. The first reason is we may release information to other school officials, including teachers within the school whom the school has determined that have a legitimate interest. Be very careful, just because the employee is on staff at the school does not necessarily mean they have a legitimate interest in the information. For example, a placement person doesn't necessarily need information regarding a student's financial aid records. So just because they're on staff at the institution doesn't necessarily mean that they have a legitimate educational interest. Number 2, to officials of another school where the student seeks or intends to enroll. There is a caveat on this. This is only in relation to PII within a student's education record as governed by FERPA. The release of FAFSA information is restricted by the Higher Education Act. We will discuss that a little bit later in the PowerPoint. Number 3, to authorized representatives of the U.S. Comptroller General, to the U.S. Department of Education. Basically, this would be in conjunction with an audit, a program review. When McClintock, for example, comes in and does a financial aid audit, we are allowed to release information from an education record in those instances without the student's consent. Number 4, in connection with financial aid for which the student has applied. Now, again, that is only in relation to PII within the education record is governed by FERPA. The release of FAFSA information is restricted by the Higher Education Act, and it's a little bit more stringent than FERPA. We'll discuss that later in the PowerPoint. Number 5, to organizations conducting studies on or behalf of the school. Number 6, to accrediting agencies, which would be ABHES. They have access to education records without consent when they are doing their reviews. To parents of an eligible student, if the student is a dependent for IRS tax purposes. The definition of a dependent student is different for FERPA as it is for federal student aid, and we will discuss when you may release to a parent and when you may not a little bit later. Number 8, to comply with a judicial order or lawfully issued subpoena. Number 9, to appropriate officials in conjunction with the health or safety emergency. Number 10, information the school has designated as directory information. However, we must give a student the ability to opt out of directory information. And again, we will dive a little bit deeper into directory information in a little bit. Number 11, to victims of an alleged perpetrator of a crime of violence or non-forcible sex offense. Number 12, to the general public, the final results of disciplinary proceedings subject to the requirements of 98.39 if the school determines the student is an alleged perpetrator of a crime of violence or non-forcible sex offense. And finally, to the parents of a student regarding the student's violation of any federal, state, or local law or any rule or policy of the school with regards to possession of alcohol or a controlled subject, if the student is under the age of 21. So if one of those reasons for disclosure without consent do not exist, again, we must get the student's authorization before releasing any PII from the education record. And again, that will be done on the release of information disclosure. This form should be completed by the student prior to release of information. It should be maintained in the student's education record. This form should be completed by all new students, regardless of whether or not they enter any third parties for release. If they don't want their information released, they're still going to complete the form. It will be blank, but they will sign the bottom. That way, if somebody is requesting information, we have the ability to pull up their form and see if they've listed anybody. This form will be the responsibility of the financial aid office during the financial aid appointment. They will make sure the student understands what parties they need to supply, and then they will be responsible for putting that form in the file. So examples of third parties that require student consent. This is a list of the top places where typically the information is requested. Parents, if we don't have information to confirm that they can claim the student on their taxes. A spouse, other friends or relatives, external scholarship entities, employers. And keep in mind, a resume is considered directory information, but if an employer wants a student transcript, that would be educational record and you would need consent. Other third parties would be National Guard, Vocational Rehabilitation, WIA, Modify, TAA. There's several other entities that would be considered a third party in which we would have to get the student's disclosure. So what would be our best protection on the front line? We typically never worry about our financial aid staff. They generally are trained. It's our non-financial aid staff members who are on the front line who really need to be educated on what can and cannot be released, to whom and for what purpose. That would be the academic department, placement department, faculty, your front desk, your registrar, perhaps even your campus president. Everybody needs to understand what they can and cannot release with consent and without consent if it's one of the exceptions. It's always our first instinct to provide the very best customer service and give people the answers to their questions, but we have to be very careful in doing so that we are not violating that student's rights to privacy. So again, all students are going to complete the release of information and it'll be in the file. If any staff member is called, mailed, emailed, questioned about any information about a student that is considered part of their education record, and if that party is not one of the exceptions that we've just gone through, the staff member should pull up the student's release of information form in the file, and they should verify that that entity, that person is listed. If they are not listed, we cannot release that information, even if it's a parent. If that person is listed, then that staff member should try to authenticate the identity of the person requesting the records. Just because I say I'm Susie Smith and I'm Sally Smith's mother, we need to attempt to authenticate that I really am mom. The release of information, again, is housed in the student's file, so that staff member would need at least read-only access to view the form. If they don't have access, they should inform the person to whom the request should be made. So again, once a student reaches 18 years of age or attends a post-secondary institution, he becomes an eligible student, and all those rights that were formerly given to a parent transferred to the student. However, we may disclose PII from an education record without consent when the disclosure is to a parent of a dependent student as defined by the IRS. Generally, if that parent is able to claim the dependent on their most recent tax year, their income tax statement, then they are allowed to receive information from the student's education record. So the parent has two options. They can complete example 27-5, which is just a form stating that they are attesting to the fact that they can claim that, or they did claim that dependent, or they can just have their student list them on the release of information form. And this is what the form looks like. This form will be on our website. So if we have a parent wanting information from a student's file and they're not listed on the student's form, we can direct that parent to our website under consumer information. They can print this form, turn it into the school. If they don't elect to complete this form, then the student would have to list them on the release of information form. Directory information. FERPA allows schools to disclose without consent from an education record when such information has been designated as directory information. Directory information is defined as information contained in the education records of a student that would not generally be considered harmful or an invasion of privacy if disclosed. Some of that directory information could include student's name, email, address, telephone, a photograph, program of study, dates of attendance, degrees or awards, grade level, enrollment status, and a resume. Obviously, our placement department sends resumes out to potential employers. You do not need a student's permission to do so. You can post a dean's list, a graduation list. All of these things are considered directory information as long as there's no part of the student's education record included in that directory information, such as financial aid, grades, as long as it's just that directory information. The student has to be given the option to opt out. A student is informed of their rights to opt out in our FERPA policy on our website under Consumer Information. If a student does opt out, it will be in writing and that document should be placed in the file. We need to maintain a list of students that have opted out each term to be sure to exclude that student from any release of directory information. I'm not aware of that typically happening. Most students want to be included on a dean's list. Obviously, they want their resumes being released so they could be potentially placed. So let's talk about the Higher Education Act. The Higher Education Act protects FAFSA information to a greater extent than FERPA. Remember, FERPA allows for non-consensual release of information in conjunction with financial aid for which the student has applied or which the student has received, if the information is necessary to determine eligibility for aid. This would be, for example, if vocational rehabilitation, they need the cost of attendance, the estimated family contribution. These are things they need to determine that student's eligibility for the scholarship. However, Section 483 of the Higher Education Act limits the use of FAFSA application data to the application, award, and administration of Title IV funds. The HEA, in fact, states that FAFSA-related data may not be released to any third party, even with consent from a student. FAFSA data is obviously any data element that is contained on the FAFSA, ICER data, key processing results, such as the expected family contribution, the student's financial aid history as reflected in NSLDS and COD data. Because this became so restrictive for the financial aid office and we were having such a hard time determining and awarding eligibility for a student because we were not able to release FAFSA information, there was a bill introduced that now allows institutions of higher education to release FAFSA information with explicit written consent of the applicant, as long as that release is in connection to determine a scholarship or a grant. So the key here is you must get their explicit written consent. So what does all this mean? Before releasing any FAFSA-related information from a student's file or any PII from an educational record, we must get on the release form the student's authorization to release the information. And again, here's a list of some of the big third parties that we typically release FAFSA information to that we now need to make sure are listed on their release of information form. We have updated the form. All the old versions should no longer be used. This new form is in Adobe Sign. We had to create a new form because the form must have the following elements. It has to have the student's name, the party to whom the records should be released, the type of education records to be released, and the purpose of the release. Each of these will be a drop-down that the student can choose one of the top parties that we typically release to, or there are a couple places where they can type in a different party if they are not listed. The student will sign this form and it will remain in effect unless the student chooses to rescind it in writing. And again, that form will go in the file. That is all we have today. Thank you for your time. If you have any questions regarding FERPA, please ask Jana Warren or Rebecca Steckman with the Financial Aid Office.